All right. To take us further in today's discussion, we have two discussants. First is the alternate chair, NBA Abuja section of business law. He's the founder of Everlaw Associates. He was a 2018 recipient of the Esquire Nigerian Legal Awards 40 under 40 category for young lawyers shaping the legal profession. He works extensively in the fields of arbitration, ICT, technology, law, and intellectual property. Since 2016, he has been a facilitator on the annual Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies. He has trainings in advanced intellectual property courses at the World Intellectual Property Organization, WIPO Academy, and is an accredited agent of the Nigerian Trademark Patents and Designs Registries, and has conducted IP registration business at the registry since 2010. He is a national representative of International Bar Association, IBA, a member of Chartered Institute of Arbitrators UK, and he sits on the panel of neutrals in the Lagos Court of Arbitration and at the Federal High Court. Sir, he's going to be talking to us on, you're going to be talking to us on your experience as trademark agent with the registry, the benefits of WIPO courses, the mediation process of any trademark conflict you may have participated in resolving. Mr. Marx Ikongbeh, you're welcome, sir.
Yeah, thank you very much, Onyekachi, and
thank you.
Thank you to the MBA Abuja Branch Interagency Committee for inviting me to just share my perspectives as an intellectual property lawyer, and so I'll just quickly jump in for the sake of our time to just share some of my own experiences, having worked in IP and worked particularly with the Trademark Registry, at least since 2010. So I'll just pick up, first of all, with some of the processes of the Trademark Registry. Even looking at the chat column, I can see a few people expressing a few frustrations with the Trademark Registry processes. I mean, I know it's a lot better than it has been in times past, and I must commend the current Trademark Registrar. They've done quite a good job, particularly publishing trademark journals. Like the Trademark Registrar explained to us at the beginning, to get your trademark registered, there's a process you have to go through where the trademark, after it's accepted by the registry, is published in the Trademark Journal to allow members of the public who might have oppositions, just like Mr. Gumiju mentioned just before I started speaking, to allow people bring in oppositions. So what we had before now was that we had a time where sometimes for 2-3 years at a stretch, there'll be no publications of journal. And what that simply means is that if journals are not published, you can't go on to finish the registration of your trademark and get the trademark certificate. Fortunately for us now, that has significantly improved. We're having Trademark Journal published really frequently at the moment. So I must, on that note, commend the Registrar of a Trademark and his team. They are actually doing a wonderful job at the moment, on that front. Now I want to turn to the issue of the online portal for trademark registration. That also was a very good initiative. I believe it started in 2012, and since then it has, worked quite well. I mean, there are teething issues here and there with the portal, but overall, what the portal had done was to really help, reduce the stress for we IP lawyers. So sit in the comfort of our offices, get all the documents together, get all the information together, go ahead, log into the portal, apply for the trademark registration, and instantly we get the acknowledgement letter, which of course is very good because you have something to give back to the client instantly to let them know that, look, I have commenced your process. But unfortunately, after that excellent performance with getting the acknowledgement letter, unfortunately, you still have to go to the trademark registry to follow up to be able to get your acceptance letter. So that, is somewhat of a drawback. Recently, there's also been some improvement in getting the acceptance letters. But lately, and I believe listening to, I think it was Mr. Temitope.
Mr. Tope, yeah, that's right.
Yes, exactly. So I understand what has happened because lately we who are accredited agents have not been able to use the online portal. So I understand from what he has said now that is because the online portal is being reconfigured to be thrown open, which I believe is in line with the federal government's ease of doing business initiatives. So to stop, to remove as many middlemen as possible from the process of using government services. So they've done that with the Corporate Affairs Commission, and that is also happening now with the Trademark Registry, which, well, in any event, is a commendable initiative. It's going to make it easier to do business in Nigeria. However, I have some reservations with that. And first of all, just a disclaimer, just to let the Trademark Registry know that some of us who paid so much money to get accredited and get a profile on the platform, now hearing that people have to just come there and walk in and get it free, we feel a little bit bad, but well, no problem. We'll forgive them for that in advance, because we understand what they are trying to do is to essentially open up the opportunities for businesses and for people to access this. But it's also important to mention, like Mr. Temitope noted, that for foreigners, even though the online portal is available, but they can't directly use that, they still need to go through a trademark or agent or a lawyer in Nigeria. But having said that, also my worry with throwing the doors open when it comes to something like trademark is that trademark actually is a specialist body of knowledge. It's not just your general area where just anybody can walk in and understand the workings. So what I would only want to appeal to the Trademark Registry is that, yes, we understand you want to throw the doors open, you want to comply with the ease of doing business requirements of the present administration, but at the same time, it might be wise to put a notice on the portal to let people know that in the course of registration, if they run into trouble, they should consult a trademark lawyer to give them specialist advice. And they should also generally encourage people that while you can register by yourself, it is wise, if we have heard what Prof has said, if we have also heard what Mr. Ogunmijo has said, the pitfalls in trademark registration, even the trademark registrar himself also mentioned that there are so many nuances when it comes to trademarks that a person who is not schooled in trademarks may have difficulties. You may register a trademark. Yes, you have a trademark certificate, but you would find out that in the day of adversity, what you have is not what the paper on which it is written, because you have missed out certain important elements. I mean, the registrar spoke about, and I believe before the registrar, the first speaker, Mr. Yusuf, mentioned, issues about generic, for instance. Your trademark, you could use a term that is generic and you don't know about it. Generic simply means that your trademark is not unique. It doesn't define, it doesn't act as an identification source between the products and you, the manufacturer. It sounds more like a general name for goods and services in that category. So you could go ahead and register that, but find out in the day of adversity when you are in court that your trademark is actually not worth it. And maybe by that time, you have built your business model on that trademark. So it's important, and I believe it will be wise if the Trademark Registry, in reconfiguring their registration portal, still put those caveats there to let people know that it is still important to consult a trademark attorney to just guide them through the process and advise them appropriately. Then I would also just want to, just also highlight, from a practitioner's perspective, the importance of trademark. A lot of people make the mistake of thinking that, like the registrar rightly pointed out, that they have registered a name in the CAC, therefore they are home and dry. But what they don't know is that in reality, trademarks have precedence over company names. So even the Companies and Allied Matters Act, the CAMA 2020, which has just been signed by the president and we are waiting to be gazetted, provides very clearly in section 852, section.
Hello, please, can you please mute yourself? I mean, mute yourselves if you're not speaking right now, please.
Okay, thank you, Onyeka.
Sorry about that.
For that protection. I thought I was being invaded. So yeah, so I was talking about section 852 of the Company and Allied Matters Act 2020, which provides, and I'll just quickly look at subsection. Okay, just simply, that section simply says that you cannot register a name as a company name, a limited company name, as a limited liability company, a limited partnership, limited liability partnership, incorporated trustees, or any other corporate entity. You cannot register a name that is confusingly similar. Just a second, let me pull up the relevant section of section 852. That would be subsection subsection D of section 852 of the CAMA 2020, it just says that, any name that will violate or conflict with an existing trademark or business name registered in Nigeria or body corporate formed under this act, unless the consent of the owner of the trademark, business name, or trustees of the body corporate has been obtained. So what it simply means with that provision is that trademarks have precedence over a company name. So the fact that your name is, you've registered your company name, whether as a business name, as a limited liability company, as a limited partnership or a limited liability partnership, it doesn't mean that, if somebody else has registered that as a trademark, that the person doesn't have the right to approach the Corporate Affairs Commission and request that they insist that you change the name of your company. So businesses need to understand, understand this factor. And then, just to tie in to what Mr. Ogunmiju said, in doing due diligence for your clients as a lawyer, these are some of the things you need to watch out for. So the fact that a client wishes to help him incorporate a company in Nigeria, you have checked the Corporate Affairs Commission, that name is not currently in use by another company. It does not mean you are home and dry. You should also run a due diligence search at the Trademark Registry to confirm that that name is also not currently registered as a trademark by another entity. Then I also just want to quickly throw in a few things about what Prof has said. Prof has painted a wonderful picture, helping us understand all the different regulators involved in, when it comes to IP issues, particularly trademark. And like Prof has said, and I just stand on that as well, when it comes to trademark, particularly, trademark actually infuses practically every transaction you can think of. So there's almost no transaction your client is going into that does not have an element that may border on trademarks. And I'll just also leverage on what Prof has said to point out one industry where we need to really be careful in doing due diligence for our clients when it comes to trademark issues. It's in registering domain names. Prof had mentioned that. So domain name simply is that, because when it comes to computers don't recognize, for purpose of the internet, it doesn't recognize, say www.iponigeria.com. What the computer recognizes actually is a set of numbers called the IP address. And those numbers look like meaningless jargon, so a long set of numbers. So imagine if when Mr. Emitope was telling us to get to the portal to register a trademark, and he called out a long line of numbers, it would be difficult to memorize. So what the domain name system does is that rather than have people memorize those long numbers, you can replace those numbers with a unique name. So iponigeria.com is easy to remember, and that's what it does. So for a business, it's the same thing. When people, for instance, I'm a lawyer now, with due respect, Mr. Ogunmiju is from the very famous and very well-established law firm of Aluko-Anoyebode. So imagine if I could go and register a domain name, www.alukoyebode.com. It means those clients of Mr. Ogunmiju who are coming with, aggressive millions and billions of dollars from China, from India, from America and US, they would go on Google, search for alukoyebode.com, the very famous law firm, and end up with Marx Ikongbeh, and of course give that money to me. Now, when it comes to IP, people think that is all that happens, that Aluko-Anoyebode is losing money to Marx Ikongbeh. But it is worse than that. Imagine that I take the money from those clients and I don't do a proper job for them. It also means that beyond losing money, Aluko-Anoyebode will also be losing their goodwill. People, those people are going to tell their, other friends back there in the US or in China, and look, that law firm Aluko-Anoyebode, they are just trash. I gave them money to help me register a company. They never did it. I called them and they would not pick up their phone. So when it comes to IP, that's the second danger of IP, that beyond stealing revenue that would have come to you, somebody who infringes on your IP also will do damage to your goodwill. So, and then just continue on that example of the domain name. So imagine I'm able to register that domain, as Marx Ikongbeh, and I register alukoyebode.com. What can Aluko-Anoyebode do to prevent that abuse? So there are many ways to go about it. So just to show you that IP issues also are implicated in criminal law. So the Cyber Crimes Act of Nigeria 2015 also creates a special offense for what we call cyber squatting. Cyber squatting simply means I don't own a trademark, but I'm simply using somebody else's trademark to run a domain name to deceive people to think they are dealing with that person. Just like Prof also pointed out the Shell case as well. So that's a typical scenario of cyber squatting. So one way Aluko-Anoyebode could go about retrieving their domain name from me would be to take a criminal action to get, to force me to return that name to them. But another quicker, faster way, which Prof also mentioned, is using the WIPO, that's World Intellectual Property Organization domain name dispute resolution system. It's a very expeditious system that a maximum in 6 weeks, tops 3 months, you can have your case decided. It's a hybrid special form of arbitration that is used. And what happens here is that all the domain name registrants are the people who manage the giving of domain names. So when you want to register a website, for instance, you have to go to a domain name registrant to buy the name. So www.alukwaniobere.com. So they are the ones who are actually in control of that domain name and assigned the domain name to me. So what the WIPO system does is that all those registrants have signed up to the Uniform Domain Name Dispute Resolution Procedure, which is managed by an organization called ICANN. That's the Internet Corporation for Assigned Name and Numbers, which in a sense is actually the engine behind the internet that we have today. So what it means is that when the WIPO domain name resolution gives an order that Marx return www.alukwaniobere.com to the rightful owner, even if I refuse to, they'll simply call on the domain name registrant, who is of course under ICANN, and force them and order them, and within 10 business days, they'll transfer that domain name www.alukwaniobere.com to the rightful owner. So it's a very quick, very efficient way to get your domain name back. And I'd like to end up on a quick case study. Prof has given us one case study of a Nigerian involved in the domain name dispute resolution system of WIPO. I'll give another one, and it's a very popular one. And then the case I'm going to give also highlights another important issue and why the Trademark Registry must be on the top of their game. So the case was actually between Jumia, the very popular Nigerian e-commerce website, which floated recently on the New York Stock Exchange, versus our own homegrown e-commerce platform, Konga, who recently had been sold to Zynox and still operate under the name Konga. So what happened essentially in that case was that when the Jumia actually is, has its origin from a company called Rocket Internet, a German company. When they came into Nigeria to start the Konga e-commerce site, they approached the man who owns Konga.com, called Simdul Shagaya, and asked to partner with him. So at some point, he went along with them, but at some point he decided not to partner with them and rather allowed them, after they had formed a Jumia, he formed Konga and started competing with them. So because the Jumia guy saw that this Konga guy was giving them a lot of trouble, and they understood at some point that Konga had intentions to expand beyond the borders of Nigeria and begin to operate in Kenya, South Africa, and other African countries. What Jumia did very cleverly was that they went to those countries, and the top level domain name in those countries. So for instance, in Nigeria, the top level domain name is www, whatever your domain name is .ng, ng being Nigeria. So you can use that instead of .com, which is .commercial. So what they did was I went to those countries, and then they primed that prime country level domain name of Kenya, Kenya and South Africa and those other African countries, Mauritius and other countries. Jumia registered www.konga. Kenya, the domain name code of Kenya, of South Africa, and those other countries. So what it meant would that be if Konga went into those countries, Konga would have trouble getting those names reserved to itself. And then it also mean that people could go on Google, search for Konga, and then end up on the Jumia website. So Konga took Jumia to the WIPO Domain Dispute Resolution Center. But unfortunately, Konga lost that case. Why did they lose that case? It was a simple issue. They had applied to register their trademark, Konga, as a trademark in Nigeria in 2012. But unfortunately, because at that time, like I mentioned earlier, the Trademark Registry was not publishing trademark journals. They were not able to finish the process of registering the trademark Konga and getting a trademark certificate. So they were not able to present a trademark certificate when they filed their suit at the WIPO Domain Name Dispute Resolution Center. All they were able to present was an acceptance letter. And so far as the WIPO Center is concerned, what suffices as evidence of ownership of a trademark is the trademark certificate. The trademark acceptance that is not good enough. And that was why Konga lost that case. So that's why it's important that the Trademark Registry must be on the top of its game, able to process quickly trademark applications and issue certificates. Otherwise, I mean, Nigerian business just lost a huge market opportunity there. And even though it may not be unconnected, but we could see that, Jumia has kind of gone up. Konga is, at the moment, not exactly, a competitor to Jumia anymore, as Jumia has far outpaced them in the e-commerce space. So it just tells us how, important it is and how relevant this issue is. Imagine if the lawyers to Konga had done their due diligence. They wouldn't have filed that case in WIPO until they got their trademark certificate. So it also emphasizes the point we have been harping on in this webinar, that lawyers, you must do your due diligence. You must be sure that your client is well covered when it comes to issues of trademark. So I think with that, I'll just end here. And then, if there are any other questions that come to me, I'll be very glad to take them. So thank you very much, Onyekachi, and back to you.
Thank you so very much, Mr. Marx Ikongbeh. You have done a wonderful job there. Thank you.
Sir.